Welcome back to Talk the Walk with me, Sarah Wong. I'm now with Carol Yuen. She's a lawyer from Singapore and co-founded the Community for Advocacy and Political Education. Welcome to Talk the Walk, Carol.
Thanks, Sarah.
We're just talking about the Singapore's new Foreign Interference Countermeasures Act, which just passed the Parliament earlier in October. Now, we're talking about its local and regional implementations. And before we delve into the legal and political ramifications of the law, I was wondering, because we mentioned that the law gave the Singaporean Home Affairs Minister new power to target activities that may introduce or may enable foreign interference in Singapore. I was wondering, does the law also create new burdens for private citizens in Singapore?
It creates new burdens if they are politically significant entities or individuals. So this applies to those who are members of parliament, political office holders, or if they have been designated as a politically significant entity. So actually, the part where they can be designated such an entity or a politically significant individual is what we are concerned with, because if the minister thinks that it is in the public interest to deem them such an entity and to implement some sort of direction where they can have foreign donors prohibited from donating to them, or they have to report their activities, then they would have such obligations placed on them.
I see. Now, we mentioned Singapore earlier. Before passing this anti-interference law, Singapore also introduced anti-fake news laws. Now, does that, the passage of these laws that apparently restrictive in nature, create an environment that is less conducive to foreign business operations, and does that undermine the rule of law in Singapore, in your opinion?
Personally, I think for businesses, no, because the designation of politically significant entities would cover those that are in the realm that do activities that implicate the realm of public interest. So these would be entities which involve political discussion, which try to influence legislative processes. So these would be this would impose more obligations on, let's say, non-governmental organizations or more politically inclined organizations rather than businesses. So only those entities would have to make declarations. But for businesses, unless they do have such a leaning, it's difficult to see them being implicated. And that's something that was pointed out at the parliamentary debates as well, as compared to the legislation in the United States and Australia. The requirements for declaring foreign affiliations are not so wide-ranging because they only apply to the designated politically significant entities.
I'm not too familiar with Singapore's political apparatus, but I was wondering, how does business lobbying work in Singapore, and will there have an impact inflicted on such activities?
I see. Business lobbying is not so apparent in Singapore, so it's difficult to see how it would directly be implicated, in the sense that the way businesses influence laws, it is normally not very obvious. It might take place behind closed doors, but it's unclear how or when it really happens. So it's not, in a sense, that it's such a big industry for us to be able to see that they are considered foreign interferences or foreign influences.
Mm-hmm. Now, Carol, you're a lawyer, so I want to share with you some of my thoughts on the legitimacy of a single piece of legislation. That recently, I read an article featuring Egypt, which approved amendments to the country's anti-terrorism law that strengthens the powers of the presidency and the military. And as you may know, that we in Hong Kong have the national security law that was imposed by the Chinese government last year to target activities suspected of subversion of state power, secession, terrorism, and also collusion with foreign power, which sounds a little bit similar with the Singapore's law here. Now, I heard arguments when I talk to government officials all the time that if you don't violate the law, you have nothing to worry about. And also the argument that goes, everyone can enjoy a certain degree of of freedom and liberties as long as you don't break the law. But to me, the paradox here is, in some occasions, including the cases of Hong Kong and Egypt, the law was introduced by the ruling power, the government, and some of them undoubtedly authoritarian, to achieve a certain political purpose that entails the curtailing of some degree of freedom, which makes not breaking the law essentially observing the loss of that right. What do you think about that argument?
I agree with you that even though people may not be breaking the laws may indirectly change their behavior, and it will definitely restrict some of their freedoms. So I think in relation to this foreign interference law in Singapore, what will happen is that the entities who may be affected by it, or individuals who are involved in these political discussions and have some foreign counterparts, will have to be very careful and will have to make their activities transparent so that they don't fall afoul of the law. Even if they have no intention of doing so, you may never know, because the foreign entity may be planning something else as you embark on your good intentions to maybe make some social change in Singapore. So it's really important to be careful and to actually take note of letting your activities be known to everyone, so you don't seem like you're doing any covert or deceptive activity.
Yeah, so as you said, that the introduction of the law already triggers or already lead to naturally some sort of self-censorship in the entities or NGOs' behavior in order not to fall foul of the law. So essentially, it's not an argument about law abidingness, but one about whether the introduction and the law itself are justified in its nature and in its implementation. And I wonder, because we have this debate here in Hong Kong, and after the introduction of the national security law, and I wonder whether similar debates take place in Singapore, that what gives rise to the legitimacy of a piece of legislation? And is it the democratic apparatus under which the bill was passed? In Singapore's example, is the parliamentary procedures, or the popular support of it, or the government advocacy, government promotion of the bill?
So, as you know, as you raised just now, this bill was passed without a public consultation process right before it, laws are easily passed in Singapore because there's a super majority in Parliament. So they are able to pass the laws. But I think what really legitimizes laws is the way that it's being explained to the public and the involvement of the public. So I think the leader of the opposition, Mr. Pritam Singh in Singapore, he did mention that it's important to have a public consultation process before bills. And I think it's been raised by civil society activists as well that this affects the trust that people has in the government, even if the outcome may be good in the end, that we have this law to protect Singapore from hostile information campaigns. It's also important to bear in mind the process and how involved the public are in creating this piece of legislation.
Now, on that note, and you mentioned the role of civil society, I wonder, from what we've seen in Myanmar and other parts of Southeast Asia, are you worried that there's a trend formulating in the region where countries are inclined to introduce similarly restrictive laws or tighten the ones they already have? And what can civil society do about it?
Yeah, I think it's really hard because they also have to try to work within the boundaries if they don't want to get arrested. Though I can sense in certain countries that people are willing to push the boundaries and make sacrifices in order to make change. I think it depends on how much people are willing to push, but I think in the sense of peaceful organization and protest, it's just important to be able to discuss and to build up a self-directed consultation process and self-directed discussion, even if there's no formal process in place. So this really requires very fast action because if there is only 1 month till the bill passes, then you just have to make use of that 1 month to do it.
Yeah. I wonder hypothetically, because the law has already been passed and the law is the law in Singapore. But I wonder if there is a public consultation period and there is substantive portion of the public or the population expressing discontent or expressing objection to the bill. Will the government, I know the ruling party has a supermajority in parliament, but will the government still press ahead with the legislation?
I think so because they are able to explain why they take certain views, and so they are able to have the final vote and say as well. I do think that in this case, it was mostly a group of civil society activists making noise, so perhaps it wasn't as widespread in terms of the concerns being raised to the government, and therefore it got some attention, but not enough to make the government change its mind. But I think when the government has set out to do something, it has taken a position and it will go ahead with the position.
Understood. Thank you very much, Carol, for your time and your knowledge and your wisdom. Talk to Walk will return next Saturday on HKIBC. I'm Sarah Wong. See you then and good night.